Thank you for attending tonight's seminar on what to do when a loved one dies. This especially hits close to home for me because the origination of this book that we wrote about what to do when a loved one dies was because when I was in my third year of law school, my mom suddenly passed away. And she had nothing in place. And since I was in law school, everybody came to me and said, what do we have to do? Well, I didn't know, quite frankly. They teach you how to read in law school, how to write. But they don't teach you what you have to do when a loved one passes away. I had to rely on other people to walk me through what I had to do at that very difficult time. More recently, my father also passed away, and unfortunately he also had nothing in place. So consider this a message of what has to be done when a loved one dies, and a warning about the necessity of getting things in place ahead of time. We have a couple of offices, one in the North Hills on VIP Drive near Sorgels and T-Bones. We also have a Washington office. One of the things that makes our firm different is we don't charge for phone calls, and we also want to make sure that we take care of things not only if you pass, but if you live as well. So the first thing we have to do, if you know someone is going to pass away, you have to find out who's in charge. See if they have a financial power of attorney, a healthcare power of attorney. If hopefully the healthcare power of attorney has been done since 2007 because the format changed. See if they have a living will declaration, a will or trust in place. When someone does pass, contact the funeral home. And this is a time when you probably want to order at least 20 death certificates. Death certificates are much more quickly obtained at this time than trying to reorder them later. And it's amazing how many death certificates you go through when a loved one passes away. Planning a funeral and planning a wedding are pretty similar. You have to contact everybody, you have to invite, you have to make arrangements for everything, and even for a wake or a party. But the difference is in a wedding we usually can plan for 6, 8 months, a year, maybe several years. A funeral we only have a few days to put everything in place. So when a loved one dies, keep that into consideration. Try to make it as easy as the person who's trying to put this all together, because this is a time where the family's at great stress and difficulties. Find the will. The will name the personal representative, the person who's going to be in charge and responsible for wrapping up the affairs of the deceased. You also have to protect the estate prior to appointment. You have to make sure that the assets are secure, that the house is locked. In my own family, my mom passed away back in '92. My great aunt, her house was robbed while she was attending the funeral. So make sure, especially if you have the last name as a decedent, that someone's keeping an eye on the house. You'd hate to see another family issue arise after suffering a tragedy such as a loved one passing away. Maybe you want to appoint legal counsel to help you walk through. Most estates, especially when there's some assets or debt involved, want the assistance of competent legal counsel to walk you through all the steps that have to be done to settle the estate. How to find competent legal counsel is, number one, start with a referral. Is there somebody you know, somebody you've worked with before? And you don't necessarily have to use the attorney that prepared the will. Sometimes it's helpful because that attorney might know where the assets are. Sometimes it's not. Okay? An old attorney joke is, how do you make a lot of money as an estate attorney? You write a lot of wills and outlive your clients, because while setting up the estate plan is relatively inexpensive, probating an estate can cost thousands, or 5% of an estate. On a $200,000 estate, a reasonable attorney's fee would be about $10,000. So you have the right to ask for different counsel, ask how many estates they've settled, how many wills they've written, and what their process or procedure, how do they bill, how do they make this process happen. Determine if you have to probate the estate. An estate has to be probated if the decedent passed with assets that are just in their name, such as a bank account. If that bank account had more than $3,500 in it at the time of death, we have to probate the estate in order to gain access to those funds. Okay? Maybe everything was in joint name or had beneficiary's name. Maybe they didn't own any real estate, just had an apartment. If everything has beneficiary designations on it or is in joint name with another person, then typically we don't have to worry about probating the estate. The importance of short certificates. Short certificates give the personal representative, the executor or executrix or administrator or administratrix, the right to sign the decedent's name after they've passed away. These short certificates, in conjunction with a death certificate and EIN number, can be given to the various banks and financial institutions to show that you're the proper person having authority to deal over the deceased estate. When you become a personal representative, you have certain fiduciary responsibilities and duties that you have to carry out. You have to obtain title to property, collect the assets, recover debts, notify and pay creditors if there's enough assets available, pay the taxes, and then after all the taxes and everything is paid, distribute the balance to the beneficiaries. The first place we start is by analyzing the will. Who's in charge? Who are the beneficiaries? How is it distributed? Is it subject to a trust potentially? Then you have to give notice and certification of notice to all the intestate heirs of the deceased, even if they're not beneficiaries. We call this the shake the nuts out of the tree letters because it essentially says you might have an interest in this estate and now's your time to make a complaint about it, and if you don't, you might lose those rights. Then you have to advertise the grant of letters. I'm sure you've seen those estate notices in the paper. They're not there because we want them there. They're there to cut off claims of creditors in the future. The law says we have to advertise that estate for 3 weeks, 3 consecutive weeks, in a paper of general circulation in the local legal journal. That allows us to get the clock running to cut off claims from creditors in the future that are unknown. If they had a safety deposit box, which we strongly recommend getting rid of your safety deposit box these days, you have to arrange for the inventory of that safety deposit box. When you have a safety deposit box, the state of Pennsylvania thinks you have the crown jewels in there and they want their tax money, so the box has to be inventoried. Even if only one spouse passes away, that box is still locked down and inventoried, even though everything now belongs to the surviving spouse. Life insurance typically can just call the companies and make a claim, and they'll send out the forms that are necessary. With debt, you have to be careful. If there's not enough assets to pay all the creditors, there's a certain order that Pennsylvania law says that people get paid. The top is things such as the funeral home, attorney's fees. We have secured creditors. We have claims within 6 months of death for medical bills. These are all priorities over general creditors. So if you have an estate that has more debt than assets, you have to be careful about who you pay and who you don't pay, or you risk being personally liable for paying those items as the executor. Tax liability. There's several taxes you have to be worried about. First of all, you have the decedent's final income tax return. Then you have state of Pennsylvania inheritance taxes, essentially a tax on the transfer of assets. The tax to spouses is 0, to children or grandchildren 4.5%, siblings 12%, and everybody else 15%. That tax has to be paid within 9 months. If you pay that tax that's due within 90 days, there's a 5% discount on the tax due as well. But you have to be careful with liquidity. You hate to pay the tax early and have a house to sell and run out of money to support the sale of the house prior to its selling. Federal estate tax. This year, federal estate tax only affects estates over $5 million. The reason we worry about federal estate tax, the effective rate can be anywhere from 35% up to a top marginal rate of 55%. Right now in 2013, the rate is scheduled to go back to $1 million, meaning any dollar over $1 million will be taxed for federal estate tax unless that is changed by the end of the year. There's also income tax issues. Not only did I mention you have your regular Pennsylvania and federal 1040, but you also potentially might have an estate or trust account, a PA 41 and federal 1041. You also have to be careful with annuities and IRAs. IRAs haven't been taxed. There might be tax due. Depending on how the beneficiary takes it and how things were set up ahead of time might depend on how much taxes have to be paid. We also have to worry about annuities with pent-up taxation being charged, or savings bonds, which is income in regard to the decedent. We might have to cash in and pay income and inheritance tax on those as well. A fiduciary, the executor, must maintain good records. Okay? Keep a checkbook. Make sure you write the checks yourself. Don't have another attorney do it. Don't pay cash for things. Because if a court or a beneficiary ever asks where the money went, if you can substantiate that, that's a breach of your fiduciary responsibility. So you have to make sure that you're able to show where all the money went at the end. There's two ways to wrap up administration. One's a formal accounting through the court, where you appear in front of the court and the judge essentially blesses the distribution of the estate. Or if everybody's in agreement, you can sign a family settlement agreement, which states here's where all the money went, here's your share, and here's your check. That's one way, when there's no dispute in the family, to save cost, time, and make the administration of the estate simpler. At the end of the administration of estate, a 6.12 notice gets filed with the court, which essentially says that whether an accounting has been provided to all the beneficiaries and whether the estate administration has concluded. Okay? Coping with illness and the death of a loved one is difficult enough. We hope we've helped you with the financial and practical matters that arise during the administration of the estate. So what should you do today if you know that you're the executor of a parent's estate in the future? Well, maybe you should find the will and trust, or have them tell you where they keep it. Okay? Talk to them about where they keep their important records and bank things, so that you're not at a loss at where they hold their bank accounts or investments. Okay? Talk about final arrangements. This can oftentimes be a difficult conversation, but if you're faced with having to bury a loved one and don't know what type of arrangements, a funeral, open casket, closed casket, church services, cremation, burial, or where the family burial plots might be, it can cause great difficulty. I know that from my own experiences. Okay? So if I want to plan ahead, what should I do with my own estate? Well, consider doing estate planning. So why do we do estate planning? Well, maybe we have a grandchild that we're not real thrilled with the idea of receiving all the money at once. Maybe you don't want to hand this guy all that money at 18 or 30 or maybe 60. But the idea is, if we plan ahead of time, we can control when that beneficiary receives the assets, so we don't have to worry about them wasting all the money at once. Why do you need a will? Well, if you don't have a will, there's two entities that have an estate plan drawn up for you. They are the IRS and the state of Pennsylvania. And I can tell you, they probably don't have your best interests at heart. So if you don't do it for yourself, the court system, the state of Pennsylvania, and the IRS is going to write your estate plan. So I encourage you to take care of yourself first. Probate essentially exists because dead people can't sign documents. If grandma owned a house and passed away, when that sale comes up, when it comes time to sell that house, grandma isn't going to be there to sign the deed. So what the court does when they go through probate is appoint someone who has the legal authority to sign grandma's name. This allows us to transfer the property, pays bill and taxes, and have the legal authority to act as if they were grandma. Why is there a lot of discussion of avoiding probate? Well, the main is probate can be very expensive. A reasonable attorney's fees on a $200,000 home, a $200,000 probatable estate, would be $9,750. That's money that could go to your beneficiaries, but instead can go in an attorney's pocket. If an estate avoids probate, the same case that says it's reasonable to charge $9,750 on a $200,000 house also says if we avoid probate, then the maximum we can charge is 1% to settle that estate. So if that's a $200,000 house that avoids probate, the fee's reduced to approximately $2,000 as a reasonable fee. A revocable trust is just a contract that you give someone the authority to sign your name after you passed away. Since we're giving this authority through a contract, we don't have to go through the court through probate to get it. Since we avoid probate, we're looking at a 1% settlement fee versus maybe a 5% settlement fee. Another thing that we see pop up all the time is, why should I be concerned about paying for long-term care? Well, long-term care costs in our area are about $8,700 a month. I don't care how big your estate is. If you need skilled care and have to put out almost $9,000 a month, that's going to make a dent in anybody's estate. Okay? What we need to do is plan ahead. The government is running out of money. We have to plan for ourselves. We can plan ahead by putting appropriate trusts in place that get the clock running. I refer to a 5-year look back. There used to be a 3-year look back, now it's 5 years, which means if I transfer an asset to the proper trust today and stay out of long-term care for 5 years, that asset would be protected for my family, for my spouse, from ever going to pay for long-term care. Since we have that 5-year look back now, it's more important than ever to do our planning early. We need to take advantage of our youth and good health in order to get that clock running, so if something bad does happen down the way, we have ourselves protected. We can also plan if you're a wartime veteran or the surviving spouse of a wartime veteran as defined by the federal government. There can be some money that we can get to help pay for home care, assisted living, or even skilled care. Medical assistance is the payment of skilled care in a facility. The issue with medical assistance, you have to be broke to qualify. There's 2 ways of becoming broke. One, to plan for it, or put assets in order to pay for it ourselves. Or 2, do nothing, wait for all your money to be spent down to either $8,000 or $2,400 and then apply. We always encourage our clients to plan ahead. My grandmother always said, clean up your own mess. And essentially that's what estate planning is. If this all seems confusing, what's the answer? Well, the answer is to avoid the biggest problem of estate planning. What's the biggest problem of estate planning? It's not taxes, it's procrastination. Okay? I encourage you to get your things in order ahead of time. Don't leave a mess. You're looking at someone who had to clean up a mess that both parents left behind. This is what I do for a living, and neither of my parents had all their ducks in a row. It's one of the greatest lessons and best gifts you can have to your family is to have everything put together on their behalf. So consider what we call a legal checkup. Just like you go to a doctor for a second opinion, come on in, find out what the cost of probate would be in your situation, what the expense would be in your situation, what the potential loss for long-term care might be if you or your spouse became ill. There's no obligation during this appointment. Just for viewing today, you're authorized to come in for a no-fee, no-obligation, free legal checkup. Okay? In addition, if you want to go to our website, at www.shieldsandboris.com or give us a call at 800-879-0984. We'll send you out one of our books. And the title for this one is What to Do When a Loved One Dies. If you want, we can send that out to you. That'll help you walk through the various things you need to do, as well as providing an estate organizer in the back so that you can begin to get your own affairs in order. Thank you for attending tonight, and have a good evening.